Hello, and welcome to the second instalment of our seminar on employee use of social media, brought to you by Howard Avram Solicitors. Today we are focusing on the hot topic of when is disciplinary action fair following employee use of social media. Whether you are an HR professional or small business owner, the use of internet and emails by your employees can be a real headache, and knowing what your responsibilities are is important to avoid getting into a legal quagmire. So we all understand that social media is now part of everyday life. It's the new normal, and with nearly 2 billion Facebook users globally, it's not going anywhere. However, it can have pitfalls in the work environment, and legal cases frequently occur. If I can start with a basic piece of advice, don't ignore the importance of social media in the workplace. Undoubtedly, employers who have in place appropriate policies and contractual wording will be better placed to protect the business than those who have not. The cases that have occurred to date and been resolved at court level are now defining what you should and shouldn't do as an employer. We're going to look at these real life cases and provide you some checklists for action within your own workplace. As we said, this is the second instalment in 4 chapters on this topic. When we finish this short seminar, make sure you move on to view the rest. So on today's topic of when disciplinary action is appropriate following employee use of social media, we're going to zoom in on 5 areas. The first, when inappropriate private behaviour occurs. Second, considering potential readership of the social media use. Third, reputational damage to the employer. Fourth, privacy of the employees. And fifth, bullying and harassment online. With the first example of inappropriate private behaviour, our real-life example is from a Lifeline project employee who shared sexist and racist views online. The court judged that they were inconsistent with the employee's work with drug users in prison and the employer's aim of providing services to disadvantaged and minority groups. Our second example illustrates how the potential readership of social media is significant. In this case, rude and offensive remarks were made about JD Witherspoon customers online. It was viewed online by a significant number of people, and the employee dismissal was deemed appropriate. Our third example is from a globally recognised brand, Apple. Given the value of their brand and the fact that they had provided a detailed social media policy and training, the courts ruled that dismissal of the employee for inappropriate use of social media was fair. This just shows the significance of the brand and commercial reputation and the impact that social media can have on that. Our fourth example concerns potential interference with the right to privacy. An employee working for the probation services and with sex offenders was dismissed following discovery of his involvement in bondage and sadomasochistic activities. The individual complained that the dismissal infringed on his right to privacy and family life. The courts ruled that interference with his rights was justified, given the activities in which he was engaged and the nature of his work. Finally, our fifth example shows you must treat online bullying and harassment as if it had occurred in the workplace. An employee made comments on Facebook regarding his colleague's promiscuity and was dismissed for harassing this colleague and bringing the company into disrepute. The dismissal was found to be fair. As an employer, you must assess whether you've taken reasonable steps to prevent employee harassment. So what can we learn from all this? Here's our checklist to help employers and employees understand when disciplinary action would be fair following use of social media. Do adopt a social media policy to encourage appropriate employee use of social media. Do inform employees of corporate image and reputation and expectations on the use of social media. Remind employees that online misconduct can amount to misconduct or in some cases gross misconduct, the same as offline misconduct would. Ensure the social media policy is consistent with other policies, for example, anti-harassment and bullying policy, disciplinary rules, and IT and communication policies. Take necessary action to prevent harassment and bullying via social media. include references to social media in anti-harassment and anti-bullying policies, and provide training to employees on appropriate use of social media and monitor it for compliance. To close off, here's a reminder of how social media is the new normal. You can see some huge numbers in there in terms of uses every minute of every day. Your staff, boss, friends and family are all involved. There are new apps and uses every day. It is not going away. Thank you so much for your time today. We hope this has provided a useful introduction to the topic of disciplinary action and social media. How at Avron focus on law for businesses, and our clients appreciate our straightforward, practical and commercial approach. We enjoy providing tips and advice for businesses that will help them keep them healthy and dispute-free. Don't forget to watch our other seminars in the series, and do feel free to get in touch if your business is in need of any legal advice.